does not go into meeting. That whatever was in the chat does not get transferred into meeting minutes or notes. So people keep that in mind. If you think something is important, relevant, you may need to pass it directly to staff or the chair, because the chat material may dissolve. Secondly, for anybody who uses screen readers because they're blind, they can't read anything in the chat. So keep that in mind also. If any of us have a participant or member of the public who's blind, they don't know, literally can't read what's in the chat. So that's another factor about the limitations of chat. Thank you.
Great, thanks, Bob. Those are really key reminders, and I think we should really keep the chat to just alerting, staff or the chair, like that you want to make a comment and not actually making substantive comments there. And I will do my best to try to announce what I see in the chat. And then Selena, you also have your hand raised. We will get to public comment, but I just want to see if there's issues to address before that.
Yeah, just to follow up on Bob's comment, I think reading aloud the chats are really helpful for people who have to join by phone too. And although there shouldn't be substance in the chat, sometimes there's a clarifying question. And so reading that aloud is very helpful.
Great, good reminder. Thanks, Selena. And then Bonifay?
Yeah, just again, following up on that, I think what might be a good idea is in the housekeeping comments section that we have, maybe Danielle or one of the staff, not only in this subcommittee, but at the full commission, we could start incorporating instructions on just kind of highlighting what Bob just spoke to, as well as what Selena said in terms of people calling in. So maybe putting in some instructions.
Yes. One other thing maybe we can also discuss is whether we should actually be saving these chats and whether we should like print them before, we actually close out. But that's something for us to think about and talk with staff as well, because that might be important for the record. But it doesn't address, I think, the accessibility issues that Bob raised, which is I will do my best when possible to read out loud. Speaking of which, we're going to move to public comment, and I think we have 2 indications from the chat that there are people who want to. So the first one appears to be Amanda Alvarado Ford, Executive Director of La Raza Centro Legal. And as far as in the chat, she just said she wanted to await instruction on how to make public comment at the appropriate time. Now is the time for public comment. So Ms. Ford, if you have something you'd like to contribute, we look forward to hearing your public comment.
Yes, hi everyone. My name is Amanda Alvarado Ford, Executive Director of La Raza Centro Legal in San Francisco in the Mission District. Good morning.
Good morning.
Thank you so much for allowing for public comment, and I'm really happy to be here as of course, the State Bar is engaged in such valuable work by enabling all of us who are the community-based legal aids to do the vital work that we need to do, especially during this difficult time of the pandemic. So I'm with you today basically with a word of explanation and to take responsibility for the fact that La Raza Centro Legal San Francisco submitted our budget for the IOLTA and EAF funding late during this round of allocations. And I just want to take full responsibility for that missed deadline. I want to assure you it's a one-time anomaly that is not indicative at all of our professionalism or our commitment to serving our clients and meeting every court deadline, every legal deadline our clients have. We meet and we win more than 90% of our cases in court and in any forum in 3 legal departments of immigration, workers' rights, and elder and disability law. I did want to note that, and this is by no means an excuse for the missed deadline. I did miss that email, and I probably missed more than one email, and I do take responsibility for that, and it won't happen again. I do want to note that we are a Latinx lawyer-led organization. All of our leadership team are Latinx lawyers, and we're from the community. We serve primarily the Latinx Spanish-speaking immigrant community. I think you all know from the news headlines, our community of Latinx immigrants has been hit very hard by the COVID pandemic. I'm also the daughter of Mexican immigrants. My family was no different. I unfortunately suffered the loss of my elderly and ill father who had Parkinson's this year. He contracted COVID in his assisted living. And so that definitely was a contributing factor. So I just wanted to make sure that everyone, understood that this is not something that will happen again. And I'd like to see if anyone has any questions or comments for us. Thank you.
Great, thank you, Ms. Ford, and I'm very sorry to hear about the passing of your father. Very sorry to hear about that. Do any members of the committee have any questions for Ms. Ford at this time? I don't see any hands raised. You're welcome to stay on, and then when we address the audit, the deadline issue, there might be questions at that time. Ms. Ford,
Great, thank you.
Appreciate your public comment.
Thank you.
Okay, and I think the next notice on the chat was from Kim Krukel, who's Executive Director at Child Care Law Center, and she's here regarding the late submission of the EAF IOLTA budget. And it sounds like you wanted to make a comment during public comment.
Hi, yes, good
Ms.
morning.
Krukel?
Yes, good morning, everybody. Can you hear me okay? Thumbs up?
Yes, we can. Thank you.
Okay, good morning, and thank you so much. I really just wanted to echo a lot of Amanda's comments. I too really commend all the staff for all of the work that they do. Reading 103 budgets is really a lot. And I want at the same time to take full responsibility for my oversight. I actually had the deadline in my calendar as September 23rd. And I was actually submitting it early on September 22nd according to my calendar, when I got a very nice email from Erica saying that I had missed my deadline, and I was quite mortified. So it was an honest mistake, and I just want to take responsibility and commend Erica and the other staff for helping me to still submit right away. Our budget was actually already in there. I just needed to hit submit. So I just really want to apologize and and assure you that we really take our deadlines very seriously and value the work of everybody on this commission and on the staff that help us to do our job. So thank you.
Great. Thank you, Ms. Krukel. Does anyone on the committee have any questions for Ms. Krukel? It doesn't appear so, but again, I invite you to.
Actually, Erica, I'm sorry, just a quick question. Will both of the ladies remain on when we get to that section on the agenda for questions, both from Center Regal as well as Child Care Law Center?
Yes, I can. Thank you.
Okay, thank you.
And it looks like Ms. Ford just said in the chat that she can stay on as well.
Thank you.
Great. Yeah. So as I had mentioned before, Bonachet's question, you're welcome to stay on. We invite you to, in case we have further questions when we consider those as part of our agenda. And then it looks like, is it Gautam Jagannathan would like to give comment?
Yes, thank you. Can you hear me?
Yes, we can. Did I say your name correctly? If I didn't, please correct me and I will.
Yeah, so my name is Gautam Jagannathan, and thank you for letting me talk. I'm the ED here at Social Justice Collaborative. We were one of the 7 orgs that submitted our budget late. And so for us, or for me, the moment I got that email about the late submission, I personally submitted this budget late at night because I didn't want even a day to go by. As you all know, we're a new IOLTA funded organization. This is our first year of receiving funding. And last year, when we went through this process, we were lucky enough to have the constant support and guidance from Christine Holmes. And this year, we didn't hear from her, we lost her, and we really haven't had the same level of support from the state bar staff. We had some admin turnover here at our office. And despite the fact that we're all working from home in this COVID pandemic, we strive to meet all our deadlines. And what really happened here is my colleague who had headed a lot of the reporting activities and frankly would create the applications went on maternity leave. And therefore I didn't get emails from Smart Simple. And so after this budget issue, my assistant emailed out to the state bar staff and we found out that I cannot be made recipient of those emails, automated or otherwise. And frankly, we don't get any automated emails. I checked in with my colleague, Emily. She doesn't receive automated emails from Smart Simple. So we're trying to figure out how to ensure that we get all of the information that we need. I've gone into the portal and I've now transferred all of those deadlines and double calendared it into my system. But we're trying to figure out how we can make sure that Smart Simple works for us because it is the primary system of contact with the state bar. And it would be great if we could get any additional guidance from the state bar if they have any solutions. I want to also say that, SJC, we take pride in winning all of our cases. The few cases we don't win, we end up winning on appeal if it's a bad judge. We've been doing this for a decade, and it really pains me to see page 7 of the memo for today's meeting. I'm standing here in front of you and taking responsibility for this, and I want to also let you know that I will be personally taking all additional efforts to make sure that all deadlines are met, whether on their budgets, reporting, auditing, or any other things. So thank you.
Thank you, Mr. Jagannath. And do any of the committee members have questions at this time? Well, let me preface. Are you able to stay on until we cover this issue in the agenda?
Absolutely, yeah.
Okay, great. Nevertheless, I'll throw it out to the committee if they have any questions at public comment time. And I'll just note, we appreciate the feedback regarding any issues with Smart Simple. I will just say, I think our state bar staff usually does a really great job doing technical assistance and supporting the organizations. If there was some breakdown here, I think we'd like to sort of figure out what's going on, but I think as a general rule, they're very helpful. And if you have any concerns, I think reaching out to them directly, even and bypassing Smart Simple might be a really effective way. So just want to make that comment. Okay, and then I see a hand raised from Joyce. Is it Gandelman? I don't know if I don't have all of your full name. So if I am missaying it, I apologize.
Yes, this is Joyce Gandelman. Can you hear me?
Yes, we can.
I'm the executive director for the Senior Advocacy Network Senior Law Project in Modesto, California, Stanislaus County. And I want to take full responsibility for my failure to meet the deadline. We were one of the 7 that missed the deadline on the budget. And when I received the email, I got the budget submitted that evening. I want you to know that I really appreciate being a member of the state bar and receiving funds from IOLTA. We started the Senior Advocacy Network about 10 years ago with a budget of $150,000. We've been receiving state bar funds for the last 3 years, and that has enabled us to hire more staff so that we can be so much more effective with serving the senior citizens in Stanislaus County. We're the only legal aid here that does work with senior citizens. And I really appreciate all the hard work that the members of the bar have given our organization over the last 3 years that we have been receiving funds. And I do support the decision to allow us in, but I do ask your forgiveness. I've been current on all the other budgets that have to be in, and I believe this was just a one-time event, and it has, opened my eyes to make certain that I don't miss another deadline. And I hope that you will allow our late submission in. Thank you.
Thank you, Ms. Gandelman. Are you also available to stay on until we cover this issue on the agenda?
Yes, I am.
Okay, great. Nevertheless, does anyone on the committee have questions at this time? No. Okay, and I'll just note a couple of additions in the chat that basically, it sounds like various members of that have made public comment have indicated that they can stay on until we address the agenda. So Selena, you have your hand raised. What's up?
Yeah, just a very short public comment. I think that from the what commissioners are hearing today, that this is yet another extraordinary year for deadlines. And as staff reflected in their memo, there were a lot of deadlines, not only for the State Bar, but also for the California Access to Justice Commission on similar grants. And even though this body has talked about deadlines in the past, I think the reality of continued COVID remote work has made this just particularly challenging. And add that on top of personal or other office challenges. I think that, you know, organizations have all said, you know, the reason why the delay, this should be an anomaly and it doesn't impact their services to clients. So I just wanted to kind of amplify the message that this is yet another extraordinary year. And I think that a lot of organizations are figuring out how to make sure that they don't miss deadlines, even with continued pandemic work.
Great. Thanks, Selena. Catherine, you have your hand raised?
Sorry, I had to unmute. I just want to say this briefly now, and I know we're having a discussion later. I guess I want to just frame that I actually think the amount of time that applications were late this year is much less than in prior years. So in a lot of ways, to me, this seems like improvement. And I think that's in part because the State Bar staff proactively reached out once a deadline was missed to the grantees, and they very promptly responded. And I to me, that makes a lot of difference. And I think that's a good practice, and kind of look forward to the discussion about what kind of latitude we can more generally give the State Bar staff. If people respond within a certain timeline of knowing that a deadline was missed, maybe they can just report to us and we don't actually need to take action, something like that. So anyway, look forward to the discussion.
Okay, thank you for the comment. Okay, I don't see any other indication that anyone else is looking for public comment. So I'm going to move us into, and I think, by the way, let me just say, I think all of the organization like representatives who came, we really appreciate you coming in and providing us with some more detail and information. And we appreciate you staying on in case we have further questions. But I will kind of move us along. I think our next item agenda on number 3 is regarding the approval of the meeting and summary action from the August 13th meeting. And first, does anybody have any comments on this? I will note, I think there is a typo in one of the headings that I will just note. This is me being nitpicky, and I'm sorry about that. But I think it's on, what page is it on? There's one where it's, oh yes, it's on page 5, heading G. I think it's supposed to be recommend applicants to legal services trust fund commission as eligible or ineligible, and it says of. It's not a big deal, but just wanted to I noticed it, so I thought I would raise it. Maybe we don't actually need to amend it, but wanted to just flag that. Pamela, you have your hands raised.
Excuse me for that. I just had a question about page 2, C. And the question was, did the organization describe how the funds are distributed to the State Bar, how they disseminated the funds, check to the person or to the landlord? How do they give their funds in terms of assisting their clients with rent relief?
I'm sorry, is this in relation to Eviction Defense Collaborative? I don't have it.
Okay.
I honestly don't recall off the top of my head if it was discussed at the meeting, whether the money is transferred to the client and then the client pays, or if it's transferred directly to the landlord to pay back rent. I'm not sure. I'm sorry.
Pamela, do you recall? Is there something you want to add to it or anything?
No, I didn't hear how the process went, but just know that that's what they were, how they kind of deviated from their primary purpose. So.
Yeah, I vaguely remember a discussion about some of the payments go directly to the landlords and that was why they needed to keep the lawyers separate from the rent negotiations, because the landlords are, there's some direct negotiation. I don't know if the actual cash goes that way, because that's why they don't want the lawyers involved, was because the landlords are technically represented parties, so you can't have the lawyers talking to them. So they kind of screen them. But I don't know if that's the same as if the cash goes directly to the landlords or not. But I don't know if we need to add, do you want us to add something about
No,
that?
just so they just explain that to the bar, how the process completely works is fine.
Okay, yeah, that's something that we can address with eviction defense counsel the next time this issue comes up, is have them provide us with more color on that. Any other comments or questions about the minutes? Okay, would anyone like to make,
Move to accept.
You jumped again. Thank you, Bob. Anybody want a second? Okay. Louise seconded.
Yeah.
And why don't we take a vote?
Connolly,
Yes.
McClogy,
Yes.
Fightmaster,
Yes.
Bennett,
Yes.
Blakemore,
Yes.
Friedman, Mann,
Yes.
Meeker,
Yes.
Nettle.
Yes.
Motion passes.
Great, thank you. Okay, let's move into agenda item number 4, which is updates. And 4A is the update on expense reports from family legal assistance at CHOC Children's. And I think Erica Carroll will handle that.
Thanks. As you all may recall, family legal assistance at CHOC Children's is a current grantee in 2021, but they were found ineligible for 2022 funding due to an incomplete application. And so staff has been working with them sort of to initiate the closeout process and to make sure that we have all of the reports that we need from them, because during the application review, we were still missing some quarterly reports as well as some evaluations. And so they've now submitted all of their 2020 evaluations as well as their 2020 quarterly expense reports. We were missing the report from the end of the year, but they've submitted that. So everything on 2020 has been closed out, and we're reviewing those reports to make sure that they conform to our records. And we are working with the organization to make sure that 2021 is also finalized on time according to our report schedule. So just wanted to update everyone that some of the outstanding items that we had talked about last time have been resolved, and we are working with the organization to make sure the rest are submitted.
Great, thank you. Any questions or comments from the committee? Okay, thank you guys for continuing to work with them. I know they've had some transition issues, so I appreciate you guys following up with them and continuing to work with them. Hopefully they can reapply for funding in the next year or two, because I think they do some good work. Okay, with no questions or comments on that, why don't we move to B, discussion and potential action on adjustments to IOLTA and EAF allocations for uncommon law based on updated qualified expenditure information. And I think this is another one that Erica Carroll will provide us some information about.
I'm actually going to have a PowerPoint that may be helpful in framing this, so I'll just share my screen real quick. So Uncommon Law is a new grantee. They're receiving funding for the first time in 2021, and they've reapplied and been found eligible for 2022. They're an organization that works in a number of counties, and they primarily engage in parole work. So the way they calculate their expenditures by county, because they're a qualified legal services project, is partially based on the location of their clients when they're doing individual cases. And then for their impact and advocacy work, they base it on the total prison population per county of commitment. And so that's their methodology for allocating expenditures per county. They notified us back in September that they had made an error in reporting their qualified expenditures, both on the 2020 application as well as the 2021. They had allocated some expenditures to San Mateo County, which does not have a prison located there, nor do they have any individual clients living there currently. So they had attributed expenses to San Mateo that should have been in Imperial County. And when they notified us of that, we looked at their allocations in that county for both years. In 2020, it was a very small amount. It was $380, which is only 0.2% of their grant for, sorry, that should say the 2021 allocation and then 2022, my apologies. So 2021, this year is $380. And then the coming year, 2022, they were allocated $1,480. When they notified us of this discrepancy, we essentially asked the organization if they have the ability to spend the funding. You know, they may not have, there may not be a prison in that county, but if they had any individual clients they might serve in that county who have been released. And they currently indicate they don't have any clients there. So they don't anticipate for 2021 being able to spend the funding. So staff had indicated that they would, if they are unable to spend the funding in that county because of the way that allocations work, they're not allowed to transfer it to another county where they operate, that we would seek for them to return the funds at the end of the grant cycle. With 2022, they also don't anticipate being able to spend the funding, but they were unsure whether they might be able to or not. And that was a question that we wanted to bring to the committee about. Because this allocation was based on an inaccurately reported expenditure, not that they didn't have those expenses, just that it's in the wrong county. If the committee would be comfortable with them spending the funding, if they have eligible clients, if it works out that way, or if the funding should be returned regardless, given the administrative error. So.
Thank you, Erica. Bob, you have your hand raised?
Yeah, couple of questions. One, what determines the county? Is it the county the prisoner was living in at the time of the commission of the crime for which they were sentenced, or is it the county in which they were incarcerated? The big question is, do you know, is it only prisoners that can be their clients? For example, what if a prisoner has some psychiatric problem? Can a family member seek advice, consultation, representation from uncommon law? If the family member lives in San Diego County and their family member is in Imperial County, what determines eligibility to be a client, and what determines the county? Is it the county of residence at the time of the crime, the county in which the crime was committed, or the county in which they're incarcerated?
My understanding, it's the county in which the person is incarcerated. And I'm not sure how many clients they have, you know, if they're successful in their parole hearing, if they continue on with them afterwards. So where that person may be residing, but I think by and large, it is based on where that individual is incarcerated when they initiate the case.
So what about, can a family member of some prisoner who's got a psychiatric problem, can a family member be represented by uncommon law? And then again, the eligibility county, which is it, the family member who seeks help or the prisoner who's got the psychiatric problem?
I would need to check with my colleague who's their staff contact about that,
Okay.
but my understanding is that my belief is that they do not represent family members. That is the individual who is incarcerated. I would want to double check, but that's, yeah.
Thanks, Bob. Jim, you have your hand raised?
Yes, Carol, is it the amount of money they're allocated based on their qualified expenditures and the qualified expenditures of other providers for that particular county, what proportion they have?
So the qualified expenditures are impacted by, I should say their allocation is impacted by a number of factors. One is, yes, the reported expenditures in that particular county. And then,
So,
yeah, go ahead.
So by misreporting the county that they had expenditures in, did that artificially increase their allocation or did it decrease it, depending upon if it was allocated to the correct county?
It's hard to tell because the amount of funding available in any county is based on the proportion of the indigent population statewide that's in that particular county. So the expenses actually occurred in Imperial, but they were reported as being in San Mateo. So it's hard to say whether their allocation would have been higher had it been correctly reported in Imperial. But yes, it does impact other organizations in the sense that they reported expenditures in San Mateo that didn't occur there, and so the organizations located there, it impacted the formula. But given that the amount was so small, it administratively seemed that it would be a burden both to programs and to staff to rerun the allocation formula. In this instance, if it were a much higher amount of money, then our analysis may have been different. But and that was kind of why we came out on that end in terms of making a decision about whether to just recoup the funding at the end of the cycle and then it will be redistributed, or whether to rerun the formula. But comparatively, as you can see for this year's funding, it's 0.2% of that organization's grant. So it's not a large amount of funding.
Yeah, I don't know, it'd be my speculation off the top of my head, since Imperial County is the poorest county in the state, that they would have been better off attributing those expenditures to Imperial as opposed to San Mateo. But that's just a guess. But it does seem like a de minimis amount to me, anyways.
Thanks, Jim. Dwan?
I just want to add, in terms of how we let programs count expenditures in counties or sometimes out of county work, but there's not a lot of guidance in our guidelines or the state bar rules, and this is something that the rules committee will have to hash out. The guidance that we give programs is we let them kind of decide where the county expenditures are. There needs to be some nexus to that, but we do let programs decide, and we ask that they be consistent within kind of an issue area. And most of the time it is very reasonable. It's usually like the county of residency for the client, or if an issue had happened in a particular county, even if it wasn't a county of residence, and if there are something that was I guess on the fringes, then that would be something we would elevate to the committee. But I just want to let you all know that it is a little bit of a murky area, and we don't have a clear kind of rule or guidance for programs around this.
Thanks, Dawn. Manashi?
Thank you. Erica, you might have already stated it twice, but just for clarity, for our sake, what is the staff's recommendation here, if any?
So our recommendation was that the organization would return the funding if they don't have the ability to spend it. But if they do, if during, say, the 2022 grant year, they have a client who maybe they worked with that's been released, because there is no prison in San Mateo County, so it can't be based on that. But if they had an individual client in that county where they could spend the funding, then to allow them to do that. But the feedback we received from the organization is they do not anticipate being able to spend it. So just having them, leaving the allocation alone, but understanding that we will receive the money back, they will return it to us at the end of the grant cycle.
And that's because, as a follow-up question, and that's because of how burdensome it would be to reallocate and go through all of that. Okay, will you be asking for a vote on this? Or is this just to update us currently?
I do have a proposed motion. I don't know if we need a vote. I think this is kind of in a gray area about whether that's within staff's discretion.
It borders kind of administrative, but we did wanted to bring it to your attention in case this is the type of thing that we should be bringing more currently, and we will then build that in the rules committee. But it is, yeah, it borders on substantive and administrative. I mean, it's a nominal amount, but in concept, I think it's kind of nice for you guys to hear what's going on.
Right, and that's really where these questions are, in concept. Yeah, thank you guys.
Bob, your hand is still raised. Did you have another comment? I'm not sure. We can't really hear you. So I'll skip to Jim, and Bob, if you have something
He
else.
might have stepped away.
Yeah, it looks like he stepped away.
Got it. Okay, Jim.
Yeah, I was just wondering, Carol, why the staff didn't recommend that they spend the money in Imperial County, since that's where the cost originally came from.
I think they can't move the money without redoing the entire allocation process. So the money, it can't, without sort of rerunning the whole process, they can't allocate that money in Imperial.
You have to spend the money that you
Where it's
received
designated.
in the county that it was allocated, absent a reallocation, because other programs would have potentially received more in San Mateo and less than in Imperial. So it's just like the nature, I think the nature of the formula. I think this is de minimis from my perspective. And if they don't spend it, you'll get the money back, and then, you know, it'll be reallocated in a subsequent year and kind of all work, I think. So I don't know whether we need a motion or not, but I think it's fine.
Jim, does that address your question, or?
Well, yeah, I understand the allocation, that you'd have to rerun the formula, but once the money's given to them, they can't. Is there a problem with them spending that $380 in Imperial
Yes.
clients as
Yes.
opposed to if?
Yes, because you have to spend the money in the county it was allocated to you in.
Yeah, it's kind of the way, it's just the way there's the restrictions on the money is that they want what's allocated has to be spent to provide services in the particular county. And so if it's not spent, then they have a bigger problem, which we would then, I assume, ask for it back anyway. Dwan, you have your hand raised?
Yeah, just one more point. This is I'm glad you agree that's a de minimis amount. This is more of just like, again, to preview for you in concept, because there is going to be an issue next year in the rules committee and how to do the out of county expenditures. And a few years ago, we actually did have a miscalculation based on an audit error from a program that was 500,000. So obviously we know this is a de minimis amount. That's a large amount. But what is like kind of the threshold? And so that'll be the quick question that will be posed to the rules committee and back to the eligibility and commission. And so we wanted it to be less abstract. And so that's why we're, again, bringing it in concept so that you can see how this plays out. So.
Thanks, Dwan. Manache?
I'm really glad that, thank you. I'm really glad that you mentioned that, Dwan. And that's what I was questioning about, is that really this is in concept, because these numbers are nominal. But the other numbers, and I recall the other facts, where is that threshold? So I'm happy that we're talking about it, and I'm happy that it'll be before the rules committee.
Does Pamela? Oh,
I'm gonna say I was trying to raise my hand, but it wouldn't work. But I think all the points are very valid, because it is about accountability, and State Bar does an excellent job of, sometimes I call hand-holding all the grantees that we see come through. So it's about accountability, that we ask them to be just accountable for where the funds are going. So this is a great discussion.
great. Thanks, Pamela. So I guess what I'm not sure about is Does anyone have any concerns with staff's recommendation that we sort of leave the allocation as it is, let the organization, if they can spend it in San Mateo, spend it in San Mateo in 2022, and if they can't, then they return it. Does anybody have concerns with that recommendation? Okay.
No.
I understand this is de minimis, but until we've actually agreed on a threshold, I think if there is a motion, it might be better for us to actually approve it just because this is in that gray zone. Once we sort of decided on, okay, below 5,000 or below 10,000 or whatever, I think it's fine. But I think this is one that it would be good for us to put our stamp on it, just so there's no questions later. If that's it, if anyone disagrees with me, I'm happy to hear that.
I agree.
I agree with you as well, Erica.
Okay, great. Does anybody, Erica, you said you have a motion. Oh, perfect. It's right up here.
I can read it out loud if you want, or.
Yes, why don't you do that? Given our concerns about accessibility, it would be good to make sure we actually verbalize it.
Sure. So the proposed motion, and if anybody has, any recommended changes, I can update it. But currently it says resolved that Uncommon Law may use the 2021 and 2022 IOLTA EAF funds allocated to San Mateo County if it has the ability to offer services in that county to indigent persons. Unused funds must be returned to the State Bar for redistribution in future IOLTA EAF grant cycles.
It looks like Catherine and Bob both have hands raised. Catherine?
So I believe this is the intent of it. So you have the ability to offer services equal to that amount, not just any service. You contact one person, might not be $1,400, but just like you do with any other expenditures, you have to show that it's equal to the amount of the allocation.
Well, they could do more.
Yeah.
Oh, yeah, they could do more. Sorry,
Right.
They could do more, but you can't do less than the amount that you were allocated. So a 10-minute phone call likely wouldn't equal 1,400, whatever the dollar amount was, but you could represent somebody and it would equal more, and then that's fine. So
Right.
that's the intent of because when it says it has the ability to offer services, it's like, it's not just any service, it has to sort of equal at least the amount of the allocation.
Yeah, I think if it were less than their allocation, then let's say they used $500 of the 1,400, then they would return 900.
So
And maybe not to be picky, but it's not just offer services, it's to provide services in the county, right? Like offering them isn't going to get you an expenditure.
Okay, thanks, Catherine. We can kind of wordsmith it. And then let's go Bob, and then it looks like Louise has some comments as well.
I'm concerned about the wording and how it might be interpreted. Quote, in that county to indigent persons. I don't know, are we sure that that means indigent persons on parole in San Mateo County? That phrasing, could it mean a San Mateo County family that's indigent and a relative of a person on parole in Imperial County? Should we say in that county to indigent persons on parole? Just to make clear, it's for the primary purpose of Uncommon Law, representing, working with, advocating for people on parole. That phrase, to me, I could see a different interpretation than solely persons on parole in San Mateo County.
I hear you, Bob, but I will say that we don't necessarily limit any other organization to what they say is their mission, as long as they're doing legal services to indigent people. I think that would be qualifying. Like, I don't think we assess whether, if Eviction Defense Council does some other legal service for an indigent person, we say, well, if it's not eviction defense, you're not allowed to, it's not a qualified expenditure. So that's my only hesitation to adding more limitations. Like, if they can provide legal services to someone in San Mateo, even if it's not necessarily parole work, I think that would still be a qualified expenditure that they could take. So that's my response to that, but let's see what other people have to say as well.
Thank
Louise,
you.
Louise, you have your hand raised?
So
And
the-
then Catherine. Yeah.
So the example that Catherine gave was, you don't use it all, you return the rest of the funds to the state bar. But so my question is, why can't those funds be used for more than one client?
Yeah.
So long as they are used appropriately. So let's say one client is like $400 and the other one's like
Yeah.
1,000. They use it up, but they don't have to use it all on one client. That's the point I want to make.
Correct.
Yeah, that's a good point. Like if they want to do two or 3 hours worth of 10-minute advice calls and that totals up the 1,400, I don't think there's any
Agree.
concern, right? Is that what you're saying, Louise?
Yes.
Yeah. Catherine?
I guess, first of all, I think we should add back in the word legal services, provide legal services, since that's what it's about. And I agree with what Louise just said. My example wasn't intended to suggest otherwise. And a legal service is also providing training to people about their rights in parole, for example, or similar kinds of things that honestly might be a effective strategy for them to use. But it's not our job to tell them how to use it. It's just to say, I think the point of the motion is they're going to use the funds in San Mateo County for qualified services. And if they do, then they don't return it. And if they don't, they return the part that they didn't use, which could be all of it or some of it.
Right.
So one more comment.
Yeah.
Perhaps the motion could say to provide qualified legal services. Just to close that door a little bit on what Catherine just said.
And I know Uncommon Laws is sort of a newer organization, but I don't, a lot of the way that we do the budgeting and all that stuff is statutory. So our motion can't really like waive, whether they have whether the money can be put to qualified expenditures versus something else. So I appreciate all of this, but I assume we can make it clear then like it has, it has to be qualified legal services to indigent people, which we've included in there. And, we will evaluate it as we evaluate every other qualified expenditure.
So if there aren't other comments, it's Catherine, and I would like to move the proposed motion as written.
Great. Thanks, Catherine.
Second.
Bob seconded.
Just need to fill up the sheet. Connolly?
Yes.
Foggy?
Yes.
Fightmaster?
Yes.
Bennett?
Yes.
Blakemore?
Yes.
Friedman? Mann?
Yes.
Meeker?
Yes.
Plantold?
Yes.
The motion passes.
Great. Thank you all. That was a really good discussion. Okay, let's move to C, 4C, which is discussion and potential action on treatment of budget revisions below 10% review threshold that deviate from expense ratio guidelines. And Erica, are you going to be explaining this one to us? This is a good one.
Yeah.
Very exciting.
Mm-hmm. Let's see. Yes, so as you all know from the memo for today's meeting, that when we initially review budget proposals at the beginning of the grant year, just prior to the grant year, guidelines that are provided to the applicants are that they should meet certain expense ratios, and if not, then they need to provide an explanation as to why they fall outside of those guidelines. And so two of the the guidelines that are provided is that they should have 75% of their proposed budget dedicated to personnel expenses, as well as 75% to programs, and then 25% or less to non-personnel and administration expenses. If there's a deviation from those percentages, that's something that staff would bring to the committee for review and approval. When we get to budget revisions at the end of the year, the guidelines for those are that an organization that revises its budget in such a way that it's 10% or less of their total award, that's something they can do without needing prior approval. If it's between 10 and 25%, that's something staff would review and is able to provide approval. And then above 25% is, again, something that would be brought to the committee for review. So the question that has arisen is if an organization, let's say at the beginning of the grant year, is approved for a deviation from these guidelines, let's say they proposed to have 70% to programs instead of 75%, and that was approved. If they then have a budget revision later in the year that falls below 10%, is that something that we need to review regardless? Because, for example, they could move more money away from programs, and so it would now fall down to 60 or 65%. If those are questions that the committee would like staff to be engaging in or to have brought to the committee, we currently don't have a mechanism for that. If it's below 10%, then we're not necessarily looking at that revision, and so we wouldn't know, for example, if it's further deviating from these 75-25% guidelines. We don't necessarily anticipate that this would be happening in many cases, because every year, as you saw from, for example, what we'll be talking about shortly, is there were only 2 organizations that deviated from the guideline. So we don't anticipate this being a common problem, but we are going to be taking a look, because our budget revisions for 2021 just came in. We'll be looking to see if that's sort of an issue that appears to be coming up. Even though organizations are not required to submit if it's below 10%, many of them do. So we're going to be taking a look at their revisions to see if this is something that should be brought to the committee. But it was a question that arose it was related to a question we received from a grantee during the budget revision process. And so since it's not something we currently look for, we just wanted to bring it to the committee for your attention and to get any feedback about your thoughts on whether that should be something we should be adding in as part of our review process.
Thanks, Erica. The only thing I'll say is this is also possible if an organization is, say, like on the cusp, right? So if they're at like 76-24, where
that's true, yeah.
There's been no need for approval of deviation, and then they make a 10%, a less than 10%, they can then fall into like a 70-30, and we will have had no chance to review that, right?
Yes, and that's actually probably an even better example, because we do have a number of budget proposals that, are above 75%, but come pretty close to that line. And so that could definitely be another scenario that would actually be more likely, I would say.
Yeah. So in essence, it's right now, there's a potential like loophole from any review, as long as you kind of keep your changes modest, which is you announce a 76-24, and then, you could, if you need to revise it, you then suddenly are 70 and 30 and no one's actually taking a look. Okay, thank you. Catherine, you have your hand raised.
I guess I've always understood the obligation to be to follow all of the rules. And so if there's something that allows you to deviate, to make a 10% change, you still have an obligation, I believe, to have your expenditures be within that 75 and 25 split. And so it would not have occurred to me to not then say I'm different than that threshold. So to me, the rules have to be read together, not as 2 separate things. And so as we're thinking about subsequent rule revisions, I just think that part should be clear. I can't see that you're going to have an exception that says, oh, you can change it so it's you're 70 and 30, but by virtue of only making a 10% adjustment, although I think there's also a maximum dollar threshold. So I don't think honestly, it's just 10%. I think it's 5,000 or 10%, I think. But anyway, that's my thought. They have to be read together.
Catherine, do you think, is your view that if there is a less than 10% deviation that affects that 75-25 threshold, it ought to come to the committee?
I don't know if it has to come to the committee. I just think it has to be reviewed by someone, right? So
Okay.
it looked like programs can do some things on their own. Then there's a second, and the next step is if it's a further adjustment, it has to go to the staff for review. And so maybe this is something that falls within the staff review. I don't know that it has to come to the commission. I just don't think you can ignore one rule by virtue of making a change that's allowed by another rule.
Yeah. Okay. Thank you. Jim, you have your hand raised?
Yeah. Are these going to be internal rules or are they going to be publicized? And the thing I'd be concerned about is, let's say we have a program that consistently shifts 9% to administration so that they always have 34% administration year after year. I mean, I could see it as a 1-year thing, but if there's a pattern, I think that probably should come to the commission.
Yeah. I think, and Erica and Dawn can correct me if I'm wrong, I think right now these are not rules, these are guidelines. No, Dawn, am I wrong? Are they rules?
So the guideline portion of the budget proposals, those are built into our application, but it's been over the years kind of uncodified office practice. I don't believe, in Erica, you can let me know, there's an actual guidelines in our standards that say the 75-25%. It's just something that the office practice and the commission has always wanted programs to do. And so for years and years, and I can't even remember back how far, we've always had that in the application. The guidelines for budget revisions, that is actually a policy. It was during the stakeholder working group process. This is what they voted to revise on. And I'm previewing for you a little bit, but because of the passage of SB 211, what the executive committee is going to recommend to the full commission is to take that functional matrix and now revisit it and see whether we stick with all of these provisions. But this right here, in terms of below 10%, between 10 and 25%, that is actually codified.
Okay,
it's
but
not
the
a
other
state bar
part is
rule that's
not
codified. The top is not codified.
Got it. Right, sorry. And the top is the one that impacts the bottom.
Exactly.
Right? Yeah, okay. Sorry. Dawn, you had your hand raised, I think, for other reasons.
That was exactly what I was going to just clarify to y'all. Yeah.
Okay.
Thank you.
Other comments or thoughts on this? Is there, right now, do we have any program that this is affecting that we know of?
No, not that I'm aware of.
Okay. Do we need to do anything formal if we wanted to say, hey, we want you to start reporting to us if you're under 10%, but you're going to impact this? You're going to affect these 75-25 thresholds?
I think we would, yes, ask you to take a vote on that if that's the direction you want to move in. We were kind of previewing it today, and we thought we would have more information maybe at the next meeting after we review the most recent round of budget revision applications to give you a better sense of, because anecdotally last year, for example, with all the budget revisions, almost always organizations were moving funds from things like non-personnel to personnel or from admin to programs. Like almost always that is the direction in which they move. So it's not really, hasn't been a major concern, or at least it certainly wasn't last year, but we were going to take a look for the most recent round to give you a better sense of, is this more of a hypothetical or have we seen any instances where it might be a concern?
But I guess I think I wanted to note is, like, in theory, they could be revising their budget if it's less than 10% and affecting these thresholds, and we wouldn't necessarily know, right? Because they haven't reported it.
Correct. Yeah.
Okay. Bonacci, you had your hand raised, but then you took it down. I don't know if you still wanted to make a comment.
Yeah, I'm kind of going back and forth between what Erica is saying. And so I have something to say and then I don't, because she kind of
handles it with the next statement. But it sounds like to me that this doesn't seem like it's a big concern. And it sounds as though the staff could accumulate more data points for us, and bring it back to us. And that this may ultimately need to go to rules where they can codify it. So it just sounds like this was more of a an update preview, as everyone is stating, that there really doesn't seem to be an action item here in terms of our taking an action.
I think that's fair. The only thing I would maybe say is if you could suggest to organizations that if they have less than 10%, they could provide the information so that staff has a good data set to see whether this is like an impact. But I agree with Bonachet. I don't think we need to like require it, but in an effort to be helpful, if they could provide their information, just so we know what's going on. Does that seem consistent? Does anybody disagree with asking the organizations for that information? Okay.
Because it would show up in the reporting. It would show up, so.
Yes, but if they don't alert us to it, then the staff literally has to like look at the proposal versus the budget and like figure out if there's a 10% or more change or less than 10% change and where it went. And so I think the idea is to try to ask them, like, can you just like tell us where your 10%, if it's less than 10%, like where you made the change, so we just kind of know where it's going. But yes, there is a way to kind of reverse engineer it, but yeah.
We do a sweep at the end of the year to make sure that they've spent down their award, but that's usually, we catch the carryover part of it. The budget revision, we don't affirmatively go in there unless there's not an easy mechanism unless they let us know below the 10% themselves.
Yeah. Okay.
So Dawn, I thought the actual rule for budget revisions was below 10% or 5,000, whatever was less.
That was revised, Catherine, during the stakeholder review process. That's why I was referring to the functional matrix. They streamlined it so there wasn't that like or it just was a straight 10% or below from the total grant award.
Right, thank
and
you.
that's why we probably should look at just that rule again to make sure it makes sense. And then where the lines of authorities are.
Yeah. Makes sense for rules.
Okay. Any other comment or discussion on this point? Okay, hearing nothing. I think now we're on to 4D, which is the 2022 meetings calendar.
Yes, so we have been working on tentative meeting dates for 2022, and just wanted to share out what it's looking like currently. The full calendar for the commission and all the various subcommittees, I believe, will be handled either at the meeting in November or maybe December. But for this committee, just wanted to give a little bit of an overview for all of you in case you notice any major concerns. We are trying to avoid, I know some of the meetings that are on the same day as commission meetings, it can be a really long day for everybody. So we were trying to avoid doubling up. There may be one or two instances where it will be the same day, but I think we've moved away from that for this next year to break it up a little bit more. So this is assuming that things stay as they are, which is, having remote meetings at the moment. It's unclear currently how things may change in 2022 in terms of bag leaking requirements. But based on the current, permissions to loosen the restrictions and allow these remote meetings, that's how we've put it together, is based on the current circumstances. So this may need to be updated, but.
So sorry, I'm just gonna ask you a really quick question, then Dawn, I'll get to you, but is splitting up the meetings the reason why a lot of them are on Wednesdays?
Mm-hmm. Yeah.
Okay. I will note, and I don't know what other people on the committee feel like, but it is actually easier for me to take off like one whole day of work and do a whole like 2 meetings than it is to do 2 hours and then 4 hours, because then I have to like make up that time and I still have to take a day off and then I still have to make up 2 hours on the other time. So that's just my, like, obviously I will adjust, but that's my little like pitch to like, I know the days are long, but it is a little easier to consolidate. But anyway, let's hear what other people say. Dawn, you had your hand raised, and then Bonish and then Bob.
Yeah, so I just wanted to make note, so you all know that Governor Newsom had loosened kind of the Bagley-Keene meeting notice requirements for this year, and that's why you all can participate remotely and not have to notice your location. That expires the end of January. We don't know whether that's going to be extended, whether that's going to be do away with forever. I know there's some advocacy groups that are advocating for those changes to stay permanent. We just don't know. I have reached out to our OGC attorney that handles kind of all the Bagley-Keene. It's not Brady, it's another attorney. And she has assured me she'll keep me posted so I can pass along the information to you. That may change then. I don't know your preferences, because if we do move back to remote and then we have to notice your location, you may not feel comfortable and want to have us do, say, video conference again. Right now, these are all assuming that I don't think most people are feeling comfortable going back to in-person. So at least for the first half of the year, it's assuming that we're going to be remote meetings. So I just want to give you that kind of context, that we might need to be a little bit flexible depending on the guidance and how the committee members and commission members kind of feel.
Okay, thanks, Dawn. Anusha?
Erica, I want to just echo your sentiment about one day. I mean, it's brutal. 4 hours, sometimes, it's 8 hours, 7 hours. I'm there with you all. But there is something to be said about them being on Friday and not in the middle of the work week. It really is. I've noticed that since we've started to do that this last year, I've been missing more of these meetings. I'm in court, I'm in something, and that has been challenging. So if there is a way, I mean, I'm counting here, 3 of the meetings are on Fridays. If there's a way in which we could push them onto Fridays, I would definitely support that.
Thanks, Manashe. Bob?
I find it mentally befogging to sit through meetings from 10 a.m. to 4 p.m. or possibly after. So the idea of separating this committee from the full commission is helpful. I'm not wedded to the Wednesday session. So what Bonachet said, if there's a way to have some Friday meeting consistently that doesn't coincide with a commission meeting, if that's easier for folks, fine. Day of the week isn't so much important to me, but to some of you when you're in court, sure, but 6 hours plus, or sometimes even when committees, this would start at 9:30. It's just mentally befogging. And I enjoy the possibility of not having to sit for 6 hours and try to keep mentally alert and on top of all the details.
Thanks, Bob. That's a good point.
If I could just jump right back in again really quick. I do want to remind our commission members here that if we do go back into in-person will be in the morning, a committee meeting, subcommittee meeting, in the afternoon, a commission meeting. That's traditionally how it's been. So it is that kind of a all day, just as a reminder.
Thanks, Bonachet. Pamela?
I'm going to say that I appreciate how the calendar was for 2021 for planning purposes. I like to plan for the year in advance. So those Friday days where I can take the time of the day for meetings really work well for planning. So the back-to-back, it wasn't often, but it was doable. So I can just keep, like I said, I plan for the year. And so just having that on one day was very helpful.
Great. Thanks, Pamela. Zahra?
Thank you. I think lots of good points in terms of like the Wednesday versus Friday, but my piece is more just like the actual dates. So in looking at my calendar for 2022, it looks like based on this calendar, I might have potential conflicts with like 4 of these dates. I don't know if they'll be for certain, but they're the kind of things that I already have on hold for items that have been scheduled. I'm not saying that we should plan around that. I just wanted to kind of share that out, that that's one of the things I observed in terms of my calendar. And part of it has to do with like the cadence of some of the dates of being whether that's every second or third week, but it's just, it conflicts with another potential meeting. So thank you.
Sorry, Zahir, is that primarily Fridays, Wednesdays, or is it not consistent with one or the other?
It's not consistent with one or the other. It's a Wednesday through Friday conflict.
Got it. Okay. I just wanted to see. Thank you. Catherine?
I have found the full day meetings in Zoom to be really challenging because it doesn't allow any ability to do most anything else, like whatever personal and professional things. I think it's different when you're in person because you actually don't have to sit in front of a computer screen. You can get up in a meeting, you can walk around. There's sort of more natural breaks. We actually take breaks to take care of personal needs. We take a break for lunch. There's just natural spaces built in. So this notion that we're expected to go from one call from 10 to 12 and then join the next call from 12 to 4 is like, if we're going to do that, then can we kind of think about how we break up that day? Like, people ought to be able to eat lunch, right? And people ought to be able not to miss a portion of the meeting and take care of personal needs. And it's really, I have found it a little mind numbing to have an expectation that I'd be in front of a computer for 6 hours.
Thank you for that. That's, like I said, you and Bob and I think have made really good points. I also agree that it's a long day. But Fridays are a little bit easier. I think, at least for me, and maybe for other people, I don't know. Louise.
Yeah, I just want to, from my own personal preference, I prefer Fridays, but I also want to comment on the in-person meetings. I mean, at this point in my life, I'm 75 years old, so I'm in that, higher risk. I have 2 under 5-year-old grandchildren who I'm, need to protect on the COVID issue. The other issue is the in-person meeting, driving to San Francisco and trying to find a parking place is impossible. They've closed that big parking garage near your office. The last time I came down for a meeting, I couldn't find a parking place. I ended up at the Marina Safeway on the phone listening to the meeting because I was hungry and I went and got a sandwich, and then I came back and finally found a parking place. And I have a handicap placard, even with that, people are always in whatever the few spaces are on the street. So, and then coming home on Friday to Santa Rosa is a nightmare. So I just, I would probably not want to attend an in-person meeting down there at this point. It's just difficult.
Yeah. Okay.
I don't mind the length or the days. I have no priorities. But.
All right. Okay. Well, we've given, do we have any other comments? Okay, Dwan and then Bonachet.
Can I just make a suggestion that maybe the 2 Ericas can work together and then figure out maybe a different proposal, and then perhaps just email the entire committee to see if we have quorum. We might not be able to accommodate everybody. I'm been dealing with this with every committee, and I think there's just going to be, it's hard to get 100% attendance, but if we can get a comfortable quorum, maybe we move forward with that.
Yeah, that's a good idea. And, and maybe we can just do like more Fridays but still split them up as a way to address, those needs. Bonachet?
That you literally took the words out of my mouth. Yeah. So that it could be on Fridays and not backed into then the commission. Yeah. And to Catherine's point, you know, if there is that back-to-back, that we give, if we can, an hour break, something in between, that it's not directly right after one another.
Okay. Well, Erica Carroll and I will confer, and to be fair, Erica Carroll actually suggested these to me. I've been busy with post-trial stuff, and so I hadn't had a chance to review them in advance. So my apologies for not being on the ball on my end, but we will confer and then send out a schedule with this feedback in mind. So thank you all. Any other comments, questions, concerns? Okay, I think we can now move to agenda 5A. And I will, I guess, turn it over to Erica Carroll again.
So in the memo that was provided to the committee, we had a few issues that need to be addressed related to 2022 IOLTA EAF budget proposals. And those being late submissions, capital additions, deviations from the expense ratios, and then possible non-qualifying activities. So, so the first item related to that were the late submissions that our office received. There were 7 budget proposals that came in after the September 21st deadline. As I noted in the memo, staff followed up with these organizations the day after and received immediate responses from almost all of them. So I think 5 of the 7 were submitted the same day that organizations were notified that they had missed the deadline, and then 2 were submitted, you know, within a day or 2 after that. And you heard from several of the organizations that that had late submissions today about the reasons for that and the follow-up that they provided. And so, you know, I would agree that all of the organizations were really prompt in following up and, you know, very apologetic about it. There were a number of deadlines. I think Selena alluded to that as well. There were many sort of competing deadlines going on during that time. So it wasn't particularly surprising that some organizations had some confusion around that, or just some challenges. And I do want to say, for the organizations that did not make public comment today, I did not specifically instruct organizations to come. I wouldn't necessarily take it as that, you know, the organizations that didn't already make comment that they don't care. I did speak with them individually. And so they all kind of fall in the same category as everybody who's spoken today. So I wouldn't read anything into the fact that they didn't make public comment. I had not asked them to attend necessarily. So that's, but yeah, so staff is recommending that the committee accept all the late submissions to be reviewed and approved as part of the budget proposal process.
Thanks, Erica. Bob, you have a comment?
I was going to make a suggestion that if these agencies all responded within a day or 2 of being notified they were 1 day late, can we blanket make a motion to accept all of these? And I hear that staff recommendation. So I'll start the ball by saying move to accept the staff recommendation.
Catherine seconds.
Does anybody have, I don't have a necessarily concern with that. It sounds like there's some other comments. Bonachet?
You know, I want to make sure that, and I know some of my fellow commission members would echo this. 1 day may not be a big deal. We are in COVID times. There, some of the executive directors came on today and shared with us personal as well as calendaring mistakes. They're understandable and reasonable. I do want to make sure, though, we're not just rubber stamping. And this goes to some of the statements that other commission members have made in the past. There is a date, there is a time It is okay for us to be reasonable with that date and time, but 90 plus other organizations submitted on time. So I think that is important for us to take into consideration. Otherwise, next year is Erica and the staff going to be making phone calls instead of to 6, 7, 8, 9 organizations to 30 organizations to let them know that they're not on time. So I want us to balance this and not directly go into a vote. I want us to have a conversation here, because one of the executive directors made a comment that they didn't receive enough support from state bar staff. And, that rang for me, because we know how diligent state bar staff are and what you all do each and every day. And yet again, 90 plus organizations were able to get their documents in and their submissions in on time. So I'd like us not to go directly into a vote, make sure that we cover some of this, and understanding that we are still in COVID time and having a bit more flexibility. Thank you.
Thanks, Bonashe. Catherine.
I actually appreciate Bonashe's remarks. I guess I feel like we have an obligation to be diligent about this process. And to me, there is sort of this difference between what happens when people submit it after one reminder and very quickly after that. And then in the past, what I had observed is organizations that were much more delayed. And so I actually think this is something that requires maybe if we're developing rules or guidelines, whatever the rules committee is going to be doing, is to be clear about when does the staff have the discretion to approve something, and when does it need to come to the commission? Because I feel like we spend an inordinate amount of time talking about late submissions almost every time we get together. And so I just think some clear guidelines, which is you will get one, I don't think they have to call people. I think an email is fine, some way of notifying people you missed the deadline. And if it comes in within, choose the number of hours, 24, 48 hours, the staff can approve it and maybe they notify us. But otherwise, let's focus on other things that I think actually have a bigger impact, and then bring to us also those that are beyond that deadline that staff can approve, like we do for other things. There's sort of thresholds that staff can approve, and then there's things that have to come to the commission. So that's where I'd like us to go longer term.
Thanks, Catherine. And Zahira, I just want to quickly read a comment that was in the chat, and then I'll give it to you. This is from, and I'm sorry that I can't remember the person who is from Childcare Law Center, but the comment was Bonashe's, Kim Krukel. Thank you. Bonashe's comment is well taken. I forgot to mention our plan to prevent our mistake in calendaring in the future. The staff person now has the duty of entering into a grants calendar all the deadlines. Okay, so I just wanted to make sure that was added in. Zahira, please.
Thank you. So, I very much, I would say, would align myself with the comments of my colleagues of the past two commissioners who've spoken with Catherine and Bonashe, because I think that this issue in terms of calendaring is an issue. I think to the point in terms of when we discuss it, that there may be this nuance. I mean, in this case, these are organizations, to my understanding, that we've already approved them. This is a matter of figuring out their budget piece. And so they're a little bit at a different cycle versus when we have the initial applications come in, which is we already have a defined pool that we know at this point who are the ones that we're working with because they've already been approved and now working on budgets. I think with the initial applications, where we end up having lots of conversations like back and forth, that becomes a moment of really thinking about, like, do we kind of have that space open? Because I think it also is an equity issue where there may be some organizations that just don't realize that, if you get it in a little bit later, it's fine. And I know we've gone back and forth about that particular piece. And that will likely continue or be resolved in some other setting. But I do think that in this particular case, because of the time period and because it's already a defined pool of applicants, and there's no one outlying who wouldn't have known to then reach out, that in this case, it does make sense. And they were also prompt in terms of the submission. I do have concerns of one of the earlier speakers in terms of speaking about the role of state bar staff. And I do think that that's something that we should just work on some of our communication on, because I know that the team does provide a significant amount of support. And there have been many times when we've asked, like, is that necessary in terms of the level of support that they're providing? And so to have someone say that we're not getting enough support, I want to kind of explore that a little bit more in terms of the capacity of that organization. And if there are things that the organization can't actually handle, that they're asking the state bar staff to handle, when that's not the position that they're in terms of the role. So I think being able to create some distinction so that the community knows the type of support that the staff can give and that they have been giving, so that there's not an increased expectation as to what the team should be doing as they're carrying out their different efforts. But thank you for Anastasia for just kind of pausing this for a second so that we could have some discussion around it, because I do think it's a little bit different from the initial submission piece. But I do think that we should have a lot more clarity in terms of when things can be submitted, because it does, this is something that we're communicating out. And then the last thing I'll add in terms of the earlier comment by LAC with the multiple deadlines is, I don't know if that reference was to the multiple deadlines that we had on our end in terms of the different grant opportunities, but that's something that LAC reviewed and commented on and said that they were okay with. And I really have some concerns where if we're having conversations earlier on where we can make adjustments, if we're told that this is fine, and then later it becomes not fine. I would like to just kind of get ahead of some of these issues so that the reason later becomes, oh, well, there was just so much going on. It's like, well, we had that discussion, so let's be thoughtful and strategic about it, rather than trying to have so many things occur that later cause problems going down the line. Thank you.
Thanks, Nahira. Those are all really great points. And I appreciate you commenting about that stuff. Lauren Klein, you're here from LAC, are you?
Yes.
Okay.
I just wanted to reiterate and clarify Selena's comments from earlier in bringing up the many deadlines that are happening now. We don't in any way mean to say that these deadlines aren't okay or that it's not workable. We definitely think it's workable. We just wanted to provide some context for how one deadline may have slipped by this small number of organizations. I also just wanted to add that I hope that you all will consider on balance these delays that were all responded to very quickly with the impact on the client communities that will be had if these organizations are penalized. There's several organizations on this list that are the only provider in their area or the only provider serving a specific community or providing a specific type of service. So there really will be a very negative impact to the client communities. And I think that's something to consider. And lastly, I just wanted to offer up LAC's help. Not to minimize the work that State Bar staff is doing at all, because they do excellent work, but LAC would be happy to assist in supporting programs in terms of juggling many deadlines and having technical difficulties with Smart Simple. If we can be providing technical assistance so that multiple people can be getting notifications from Smart Simple, or doing anything to help manage deadlines, that's something that LAC is very happy to work together with State Bar staff to do to help avoid some of these problems in the future.
Thanks, Lauren. One comment I'm just going to make, because this has come up a lot, is that there is sort of this comment that the committee needs to consider the impact on clients. And that is a fair point, and we do keep that in mind. But that is also something I think the organization need to keep in mind when they're dealing with deadlines. Like, they are putting their clients at risk when they don't submit the deadlines. Now, I think there has to be a little bit more like of a rule about this, or maybe there needs to be, for audits, we require extraordinary circumstances, something like that. But I just want to say, like, we are not the ones who are late. And so it is not actually entirely on us that their clients are at risk. And I just want to make that point because that's come up a lot. I'm not saying that we don't consider that, but it's something for the organizations to think about too. So that's just my little response to that. But I do thank you for your comments, and I don't mean to be like pointing at targeting you in particular. It's just something that's come up a lot, and I want to make sure we're balancing who bears responsibilities in these issues. Okay, Danielle, then Bonachet, and then Sigra.
Hi, yes, thank you. First, I actually wanted to read a comment that Gautam just entered into the chat in response to our discussion about his earlier.
Yeah, thank you, Danielle.
I wanted to say that none of my comments during the open session are to be interpreted as maligning support from the state bar. We, as a new recipient of funding, had a certain intimate level of support in 2020. We at SJC appreciate all the support and guidance from State Bar staff members. I will accept responsibility for our mistakes in failing to file the budget on time as a newly funded organization. I also just wanted to provide, I won't speak for other State Bar staff, but as a State Bar staff, I am the staff contact for Social Justice Collaborative. And as he mentioned, they're a newer organization to be funded by IOLTA EAF. And their previous staff contact is no longer with the State Bar. And so I think it was kind of an unfortunate combination of circumstances where they were newer funded. And I think for a period, they did not have a primary staff contact, or at least it wasn't like as close a relationship as it otherwise would be. But I did want to also mention that this is my first time hearing of, that they're not receiving Smart Simple emails. So that's something that we'll work on with them to figure out from a TA perspective.
Thanks, Danielle. Appreciate the staff feedback. Bonachet and then Zahra.
So just to echo some of what you just mentioned, Erica, this isn't to pick on what you just said, Lauren, but it isn't our responsibility to make sure organizations are serving their constituency. Our role is to support that action through funding and oversight, but it isn't our role to do that work. So I really want us to stop using, I personally, after nearly 12 years of being here, would suggest we stop using that basis for an argument structure. The other is, I don't hear that the staff need any additional support in supporting these organizations. I think that also needs to be said here. The State Bar staff is well-equipped, well-run, extremely efficient, and they know what they're doing. Thank you for stepping forward and extending the hand through LAC, but I think it's important for us to know what LAC's roles are and what the State Bar's roles are, and not create a potential confusion. So just on those 2 points.
Thanks, Bonachet. Zahra?
Thank you. And I'll just keep it brief because I just wanted to, echo and just share my agreement in what both Erica and Bonachet said. I do think that the argument in terms of what it does to the clients is something where if we could move past that in terms of that type of discussion and talk about what the issue is at hand, and how these different organizations can really focus on the needs of their client by getting materials in on time. Just in terms of what Bonachet was also just sharing in terms of the responsibilities and roles of the different organizations. I know that the staff team has done just an incredible job and just does so much work in terms of communicating with organizations. And I think in those cases where some of that communications then create these relationships where organizations are confused about the role of our staff team and what they're supposed to be doing, I think that everyone's getting the appropriate amount of support, and they're getting really extensive support. And so I really also appreciate the additional comment that was put in, and just want to echo the fact that like what we do see is that the staff team providing very, exceptional support. And so, thank you for the offer. And I know that the team really has the tools that they need to kind of move forward.
Great, thanks. Thank you, Zara and Bonachet, both good comments. One other thing I will just say, we did this, I think, when we did the application deadline issue, which was, we sort of recommended that at some point we should have some kind of, that like the audit extension requirement, that there be some, that essentially there has to be some standard for why things are being submitted late. And whether that's, to Catherine's point, there's like a threshold. It's, you get 24 hours grace period. And then after that, you got to have an explanation. That may all need to be resolved in the rules committee, but I will echo my view, which I articulated, back in the spring, which is, I think if we're going to be doing that, that we should have some standards by which we assess whether late applications are, should be accepted or not. Right now, we don't really have those, and it makes it very difficult for us to have this to assess. It literally is kind of an all or nothing. So that's just my 2 cents on this as a future view. Any other comments, questions? If not, I think we still have this motion that Bob moved and Catherine seconded to accept all of the late budgets. Any other comments on that? Okay, if not, I think it's appropriate to, move into a vote. Is that okay, Erica?
Connolly?
Yes.
Cloggy?
Yes.
Pipemaster?
Yes.
Bennett?
Stayed.
Blakemore?
Yes.
Friedman? Mann?
Yes.
Meeker?
Yes.
Lantold?
Yes.
The motion passes.
Great. Thank you to everyone. Thank you for a very good discussion. And, hopefully we can make some improvements on this.
So I just wonder, is it appropriate for a couple of us to volunteer to work with the State Bar staff to kind of come up with a set of guidelines until there's a rule about this that we could present, and then we would all be clear about this rather than, I really appreciate the discussion. It just seems time for having some guidelines. And so I'm volunteering to do that if that's an appropriate role. And if not, I'm happy to have the staff work on it. I just think we need to come back with a proposal about what is a reasonable approach at our next meeting so that we can kind of have a framework for the discussions.
If I can, Erica, jump in. I think, again, we have been discussing this multiple times, and I'm glad that Zahira made the distinction between this vote versus applicants that are coming in late. And so there really is a way to look at both of those two. But maybe as chair, Erica, you can work with the staff and you guys can frame it for us and we can begin the discussions.
Sure. Yeah. So I don't want to step on the rules committee's toes, but I think it's a good idea to Catherine's point, to get something in place. Catherine, maybe you and I can kind of team up and work with the staff and try to come up with something. Dawn, you have your hand raised. Do you have some thoughts on this?
Yeah, Erica and Catherine you guys are both on the rules committee, and maybe for that working group, we're going to look at the work plan, and maybe we can, move that topic up earlier in the year, and then the two of you can volunteer to be on that working group. Would be great.
Yeah, that might be a way to do it, is to kind of expedite it on the rules committee, and Catherine and I can maybe team up and sort of work on it with staff, assuming staff is okay with it, kind of getting that put together before the next round of deadlines. Okay, we'll follow up. Catherine, I'll follow up with you and Dawn, and we can sort of work from that. All right, the next topic is capital additions, and I'm going to step away for just a second to use the restroom, but please continue going, and I will be back in to moderate in just a second.
Thank you. So yes, the next topic was about our guidelines regarding the purchase of real property, and which we also have applied to capital improvements. So organizations that propose capital additions in excess of $5,000 or 5% of their grant award would need to have those allocations, those budget parts of their budget proposal approved by the committee. This first came up, I believe, when budgeting for 2020. These guidelines sort of were being applied for the first time in quite some time. And so they indicate that, yes, if an organization for either IOLTA or AF would need to have it approved. The other thing to note about EAF non-personnel and administrative expenses is that they need to be tied to the funded activities. There needs to be a relationship between what the amount that's being proposed and the activities under the EAF grant. So this year, Neighborhood Legal Services, in the memo, they had initially allocated, I believe, 10,000 of their IOLTA funds and 25,000 of their EAF award to capital additions. We weren't sure at the time what amount of that would be devoted to either real property or capital improvements, because some of it was more tangible personal property, which is under a different set of guidelines. But NLS responded and indicated that they weren't sure yet exactly how the funds would be used. It was more in anticipation of some sort of unexpected costs, or if an unexpected need were to arise, that they would have these funds on hand to pay it down. Based on State Bar staff feedback, they revised their proposal. It's now $5,000 each of IOLTA and EAF, so they've reduced their request. I would say that, our recommendation initially as staff was that because these funds, we don't necessarily know how they will be spent yet. Our recommendation had been for the organization initially to reallocate those funds to something where they have a certain expense, that they know the expense or they anticipate a certain amount. And that if they needed to revise later because of some unanticipated event, that they could revise the budget rather than allocating it to sort of a reserve at this point. So I think given that NLS has reduced their proposal to $5,000 each, and as you can see, their 2022 award, for IOLTA is $991,000 and $1.6 million for EAF, that we were more comfortable with the IOLTA proposal. However, the EAF, because these are unknown costs at this point, they can't actually tie them to the EAF activities at this moment, because it's not a specifically planned project where they can show the relationship to the EAF activities. So we had some concerns about that. But Danielle was the staff contact for NLS when reviewing this budget, and so I think she might have some more details to share about that.
I think that was a great, oh, I'm sorry.
No, you're fine. Sorry, I was gonna tell you to talk, but
perfect.
You did it.
Apologies for jumping ahead. I think that was a great summary. I don't think I have anything to add to that. I just wanted to point out that Lynn Hyortal, and I apologize if I'm mispronouncing that, is on hand to answer questions, and she's their Chief Financial Officer. So I just wanted to point out, if the commission has questions specific to the organization, that can be handled.
Thanks, Danielle. Are there comments or questions? Pamela.
My only question when reading through was, it took me back to when Helen Hong was the chair of the Office of Access and Inclusion, and they had that lump sum of funding, and it was geared toward capital improvements and paying down mortgages. are these the same funds that they're having to work with right now? And if so, that would be a different group than we're working with now. So is this something that's tied to when Helen was here, or brand new funding and brand new capital improvement and real property
Yeah,
purchases?
it's new funding for 2022, but it is falling under the same category as what we dealt with in 2020 with things like the mortgage pay down or major construction costs. So it's the same category, but new funding. So, and in those cases, that was sort of the distinction that we were trying to make is in 2020 with those proposals, there were specific intended, those funds were dedicated to a specific project. My understanding of this proposal is that they are not dedicated to something specific at this point. It's to be held in the event that they need to use the funds, but we wouldn't know at this point what they're actually going towards. So.
Yeah. So I will just make a quick comment. To me, this issue is not about the amount of money. It, to me, is about the concept of whether you can allocate money, any money, to that's not to, non-personnel or admin expenses without tying it to something. And whether that's 10,000 or 5,000, that to me is the concern. And my instinct is that is not something they should do, that it should be tied to a particular expense. And that if it is not tied to, if something comes up, they can then request a budget revision later. And that us sort of giving them sort of pre-approval for that without having any say over what they end up actually spending it on is a little bit concerning to me. And so that's, I think we sort of talk about this with the carryovers. We don't want organizations to have reserves. We want them to spend the money. We've asked the legislature for more money so that they can spend the money. And so I understand that incidentals may come up and they may want to revise the budget later, but I think even if it is, it to me is a distinction with a difference, that they should have to allocate the money to things that they know about. And if there's something unexpected comes up, then that's why we have a budget revision process subsequently, which is what other organizations have done. So those are my 2 cents on this particular issue. And I hope, I'm curious what other people on the committee are thinking.
I just wanted to also note, it looks like Lynn from NLS has her hand raised.
Oh, okay. Lynn, yes, please.
Hi, good morning, good afternoon, everybody. Thank you so much for having me and your support of legal aid. And especially thank you so much to the State Bar staff. You all have been so very helpful to us throughout this entire process. Thank you so much. Our EAF doubled in 2022. And so there's 2 sort of conflicting things. One, we were trying to just create the best strategy possible for EAF funding. I know a lot of organizations consider doing a 2-year proposal for EAF funding. We did not do that. We decided to do a 1-year proposal. Secondly, we have we own 2 of our buildings, but one of our buildings is extremely old and it is right in the path line of a City of Los Angeles Metrolink train station and line that's supposed to be coming either right through or right near our building. And the building needs a lot of repairs, but it's kind of silly to put significant dollars into a building that we're likely going to lose in a couple of months, if not a year or so from this time. So the reserve was intended only if something were to arise this year in this building that again is very old and might need a new HVAC unit, but it's not something I would want to put in right now if I'm not going to be in that building 2 years from now. And again, just trying to strategize, do we spend EAF over a 2-year period of time over 1? I respect the committees and the staff's decision either way, however you approach this. I just do want to point out though, it is helpful to have some type of capital type of reserve, special for larger organizations like ours that we do own a lot of our buildings, or the buildings that we're in, we are responsible for the building upgrade and maintenance. As you can see, this is a significant, both IOLTA and EAF combined are significant portions of our overall budget as well, and moving from staff and clientele to a 200% poverty level in 2022, it really does encompass 95% of what we do, the bread and butter work of what we do at Neighborhood Legal Services. So that ability to use either IOLTA or EAF funds for capital infrastructure is very helpful. We do have legal services funding. However, just like you all, they have strict regulations around what can and should be used with their dollars, and with your dollars as well too. And they have something now called proportional share, where although I can get Legal Services Corporation to pay for the bulk of a capital item, they're not going to pay for all of it. So having that ability to put some of it on an IOLTA or EAF grant is very helpful. But again, I respect the committee's decision either way. We've offered to reduce our budget down capital to 5,000 each, so that wouldn't be something that would need to rise to the commission's level. And certainly we appreciate the opportunity to submit a carryover request or a budget modification on time for you all to consider if something were to arise throughout the year. So please let me know if you have any questions.
Thank you, Lynn. And I should just say, like, my comments are by no means to indicate that I think you guys are doing anything problematic. I understand the reasoning behind it. I think it's just for me, it's partly a conceptual issue as far as how we want to deal with these like budgets and stuff. But I understand like where you guys are coming from. Zahira.
Thank you. I think kind of picking up on your comments earlier, Erica, in terms of this piece, that what I kind of see as a challenge here is that in an ideal world, like nonprofits should have reserves. They should have reserves that help float them through lots of challenging times. I think the issue here is this particular pot of money and how it's designated in terms of the use for services and the use for specific things in terms of those who are indigent. And it seems as if like what NLS is suggesting in terms of the allocation, that for some of the private resources that they receive, that may be a use for some of those resources, because otherwise we'd be talking about, there were a couple of things that were sort of shared. First, we're talking about using these resources for something that is uncertain and an uncertain amount, and having money kind of parked someplace for a little bit, which is, happens all the time with private resources, but for these resources, especially as we go back every year and ask for more money, it seems, somewhat problematic in terms of like the messaging. But then the other piece is that even in terms of use of these resources for something where it sounds like it may be for something that may not even fully depreciate out in terms of the use, because it would be going into a space where that space in total might be demolished, or they might lose the space. And even for private funding, you would look at like the full depreciation out of an expense that you are contributing to. And so I think it's an interesting question, but it's not clear to me like why there wouldn't be the use of private resources in this case. And also it seems like what I'm hearing is using, this money for something that's uncertain, and that from an accounting perspective won't have lived its useful life before this space is potentially demolished. And I know that when we've talked about capital expenses before, we've gone back and asked for additional budgets. And we also asked about that kind of, what is the use? How long is it going to be useful for? And here, if it's not going to be useful for a very long time period, it's unclear why we would use these resources, which are very specific for something like that.
Thanks, Sierra. Appreciate that. Bob?
I like the phrasing of the staff recommendation. As far as holding funds for an as-needed basis, the example cited raised questions in me about really, like, if there needs to be the HVAC system replaced in this older building, would it really only cost $5,000? It just seems like, do you have a bid estimate? It seems low to me, and therefore holding $5,000 in reserve, if allowed, A, it might not be enough. B, if there was a replacement of HVAC, wouldn't that affect then the eminent domain assessed value if the city of Los Angeles says we're taking the building? I don't know how LA does its eminent domain, but it just seems to me like holding this money in reserve for a use that if the HVAC system did crap out, wouldn't that affect clients? Wouldn't that affect your staff if you didn't have heat, if you didn't have airflow air conditioning in the hot times that LA experiences? It just seems like not repairing HVAC could harm the clients. Holding in a reserve until it really stops, I wonder, is that good use of any reserve of whatever nature? So to me, it's either spend it or the staff recommendation, budget for known expenses and revise later.
Thanks, Bob. Appreciate your comments. Erica?
I just wanted to respond briefly to what Bob initially questioned about the expenses. So one is that it's at $5,000 now because the organization, in response to discussions with staff, they've actually reduced their proposals. Initially, it was $10,000 of IOLTA and $25,000 of EAF. And I don't think that the organization is saying that this will cover the entirety of the expense, but rather that they would like to attribute some of this funding, pool it together to meet their needs to the extent that they are permitted to do so, but not that they're necessarily saying this will actually meet the entirety of the cost.
Thanks, Erica. Other comments or questions? So my sense is that we're sort of the committee seems inclined to say we are not willing to approve kind of holding stuff in reserve without identifying what the money is going towards. But I don't know if that's true. Is that kind of where people are lying? Oh, sorry, Bonachet and Catherine both have comments.
Yes and no.
Okay.
We've allowed for carryovers, so I think that might be a little confusing. But in this instance, I don't have maybe Dwan, you could share out. I don't have a recollection of where we've allowed for this kind of earmarking and setting aside. Do you have a kind of a historical reminder?
Yeah, I mean, and Erica, Carol, and I talked at this, and this would be as far as we know from our records and our both of our times here. The commission hasn't approved this type of setting aside or putting it earmarked or reserved without a known kind of expense.
Yeah, that's so I just wanted to make sure. Thank you, Dawn. Eric, I wanted to just make sure that, again, we're making distinctions on this in this meeting, which I think is really good. We've been allowing for carryovers and for organizations to hold on and earmark funds for later, but that's not what this is about, right? And so I think I'm where Zahira is, which is these funds are to be spent, not to be earmarked, and we don't have sufficient information as to what the costs might really be, true costs.
Sorry, just to make sure I'm clear on the carryovers. I thought carryovers kind of happened at the end, towards the end of a year, when there's sort of surplus money. And I think that has to be incorporated into the next year's budget.
Yes.
Yeah, so it's not, we don't allow carryovers to be sort of designated, do
That's
we?
right. No, that's right.
Okay, I just wanted to make sure. So there is sort of a difference between the two. I understand. Yeah, okay, just want to make sure. Catherine.
I think my point was the same, which is this isn't really a reserve because the money absent a carryover request would have to be spent in the current year, right? So this is really just how is it categorized currently, right, in the current budget? And I guess what I don't know is like we're kind of into the weeds about are they going to spend it on an air conditioner versus something else? Is it allowed to have sort of building maintenance expenses as a line item in your budget, or that's not allowed? That to me is kind of what this is about. Not about a reserve, it's about a current year proposed expenditure in a category, and I'm just not sure if the category of like building repair or maintenance is allowed.
Yeah. Yes, it is. I think when it was initially proposed, a lot of things were grouped together in the same category. And so it was a little bit unclear as to how the funding would be spent, because some of it was building maintenance, some of it was, technology costs. And so then when we asked for more details about it was when we understood that it wasn't actually going to be attributed to anything in particular at this point. It would kind of be determined at a later time.
But I guess so generally when the staff is looking at these for purposes of a building repair or building maintenance cost, what do you require programs to say, like, I'm going to spend, I don't know, annually we anticipate that there's going to be plumbing repairs needed and it's going to be X amount and therefore we're budgeting that because that's based on our historical. I realized it. I'm not sure this is worth a lot of time. It just seems like I can kind of go either way, but it seems like you allow building maintenance and building repair, and it would not be my experience that people have to be down to the very specific thing they're spending it for. I don't find $5,000 for building repair because historically you're going to have to make some repairs potentially to be out of the ballpark. And if they don't spend it by the end of the year, they're going to do a budget adjustment the other way. So it's like, are we saying pretend like you're going to spend it on something else and come back to us if you need a repair? Or are we saying a repair is an allowable cost in your budget? And if you don't spend it this year, either ask for a carry forward or reallocate it to something else. That seems like where we are. I mean, it's not. Anyway.
I think I guess 2 points. One is, yes, if they're just making routine, repairs, that's not an issue. Our concern was raised based on the initial amount that was budgeted and whether it was rising to the level of a capital improvement rather than just a sort of everyday type need. Because if it was considered a capital improvement, then that would be something that would need review. If it was, routine maintenance, it's not. And then the other thing is, regardless of the amount, particularly with respect to EAF, if they don't know what they're spending it on, we can't necessarily say it's tied to their EAF activities at this point, like that it's in proportion to their EAF activities. And so that was the other
so now we're at a place where it's not the larger amount, it's $5,000, which isn't going to really be a capital expenditure, but it might be like a repair of air conditioning, right? And for EAF, are you allowed to include kind of routine repairs in your budget, and it's prorated maybe across the counties of the people that you serve? I mean,
EEF, that's not really typical for EEF expenditures. There is that line item, but they would have to kind of justify. I haven't seen that in recent years. Erica Carroll she's manages the staff, is more in the weeds in it. But the EEF, we work with Judicial Council, and it really needs to be connected to the expenditures. I mean, similarly with our HP grants, we've been told it needs to be when we get audited. So those are some of the questions that we are asked. So I think it's more strict on the EF side.
So for EAF, it's not allowed that you would have just a line item for repairs because you can't routine repairs because you can't say what's going to actually happen. But for IOLTA, you can. right?
I mean, we have that the way the budget application is built. There's the same line items for both IOLTA and EF, but if they do propose the budget for EF, we would elevate it to like we are
Yeah.
now. So that's why you haven't seen it yet. I don't know conceptually if that happened like previous 6 years to the time I was here. I can't say for certain, but I know my recent memory that hasn't happened because it needs to be like again that tie to the EF activities, and so programs have steered away from that.
And that's my recollection too, is that it's that we haven't done this.
Sorry, but is this $5,000 in the repair line item?
It's not, right, Erica? Danielle?
Under capital additions.
Yeah, that's why it's triggering this conversation.
Okay, so where is it then? I'm completely confused. So where is it?
Actually, if I could just, Lynn may want to answer some of these questions.
Oh yeah, fair point.
She's here.
Hi, I'm Lynn. I'm here. So the intention, again, on average, we may need to replace 1 or 2 HVAC units a year. And any given HVAC unit could be, let's say, $10,000, usually not more than that, but up to $10,000. And we would not allocate that entire $10,000 to IOLTA or that entire $10,000 to EAF. Again, the Legal Services Corporation would take the bulk of that cost, probably well more than 60% of that cost, or $6,000. So then I just have $4,000 I've got to either use unrestricted dollars for or to utilize these funds. So they truly would be capital in that regard. I do have them in capital. And you know, repair again would be an expense, and it would show up more under the occupancy or the space area under the budget, and that is already built in normally. But these, what we're sort of referencing here, would truly be an unexpected capital item, but one I already have to reserve for. The question is just whether I ever have the opportunity to use these IOLTA or EF funds, or whether I do need to rely on unrestricted dollars. I have very few other grantors, and we have over 40 fund sources that will support anything in relation to capital additions, capital improvements, or even routine, just general building maintenance. So the ability to use these funds in any capacity, even in a much small capacity like $5,000, is greatly appreciated.
So I think, if I remember correctly, Dwan, you can use IOLTA funds for capital expenditures. I think it's challenging to do that under equal access, as I recollect. So it almost seems like we have to sort of make a distinction between, like, all of this is in, like, there's one rule that would apply to IOLTA and EAF, and I think there's actually different rules. So that's the first part. And then for IOLTA, so if we say, you can't use EAF for capital expenditures, and so you're going to have to get rid of that part, but you can use IOLTA for capital expenditures. Then the only remaining question is, can you budget for it in advance based on the historical information you have about the expense you're likely to incur, or does it need to be backed out and you just make a budget request at the time that you need to do it? That seems like where we are.
But I don't think that's entirely the right the right way of categorizing this, because they're not budgeting for the HVAC. They're budgeting, just for unknown capital expenditures. The HVAC is a potential example. And so the issue is, we have traditionally said, if you're going to do capital expenditures, you have to identify what it is you're going to spend that on. So if you're going to spend it on the HVAC, that would be a different analysis that we could assess. But right now it's basically, could be the HVAC, could be this, could be that.
I'm actually not, I'm just saying, I think where we are is we're focused on IOLTA, and then the decision has to be whatever that capital expenses are. Either it's allowed to have a small amount of money in a capital line item, or instead, then it has to be only at the time that you need to spend the money. So I guess I'm just trying to go to Lynn's point, which is IOLTA can be used for capital expenses different than other grant awards. It seems like the staff is saying, we don't really want to include it in your budget as a capital expense because it doesn't provide enough detail about what the capital expenditure is. But if you need to replace HVAC or a plumbing system or whatever it's going to be, do a budget revision and come back to us. And if it it falls within our guidelines, then we'll be fine. So I'm fine. I
Yeah.
just, but that's different than EAF, and all of this kind of got
Yes.
lumped into one thing. So it seems to me the rule is EAF doesn't accommodate capital expenditures. We're not going to do that. IOLTA does, but we don't want it in the budget unless it can be identified as what the capital expenditure is, so we can do the review that Pam, I think, referred to earlier. And so give us a different budget now, but no, you can come back later with an IOLTA capital expenditure.
Yes, that's my position.
I got it. I think it's
that
fine.
is-
I think we
yeah.
should trust all of you. I'm just trying to be clear about what it is we're.
And
what
also
we're saying.
I think what Catherine is doing is trying to understand it for herself as well.
Sure,
She's
sure.
Speaking it out
I'm trying
loud.
to remind
to
myself
try
of
to,
the rules
yeah,
here.
she's trying to understand it herself. So I think what we have here is the proposal, the staff recommendation is for IOLTA, and it's a no on EAF. So I think we just need to change the languaging here, Erica, and then we can go forward with what you're asking us to do. And give us more clarity on the staff recommendation based on these discussions. And thanking Lynn for being here to.
Oh, yes, that
these
is
questions.
Thank you very much. And sorry, Catherine, I didn't mean to be rude in how I was explaining it. I was just trying to.
I'm perfectly fine. I can be long-winded. Just trying to think about, like, trying to understand it.
Yeah.
So it's really the staff recommendation is to not allow EAF capital expenditures, to allow them under IOLTA if there's a specific expenditure for a specific item that can be reviewed, and therefore submit a budget that doesn't include a general line item in IOLTA for a capital, a to be determined capital expenditure. That's really what we're saying, I think. And then revise your budget if you need it.
Yeah, Erica, Dwan, is that an accurate statement of what staff is recommending?
Yeah, I mean, I think, and yes, in the most simple terms, it would be that they revise it to eliminate the capital additions unless and until they have a need, and then to bring it back with a budget revision. Yes.
Yeah, Erica, maybe the only thing to add there for your recommendation is IOLTA. Right?
Yep.
Because it's EAF is not possible under the guidelines. So just, I think the only thing to add in there, staff recommendation to grantee is to budget for known expenses under IOLTA, potentially as languaging, and to revise later if necessary, something to that effect.
Sorry, it's really for known capital expenses and to revise, because we're right. That's what we're talking about. It's just not any known expense.
Well, the original recommendation was, is they said they didn't know that of any particular capital expense to move it to some other line item.
That's okay too. I was just saying in the staff recommendation, it just refers to known expenses. I was just trying to clarify what we're talking about is capital.
Catherine, Erica means just, Catherine means to just add the word capital before the word expenses. I'm translating for you today, Catherine.
Thank you. That's fabulous.
I got you.
I think Danielle had her hand raised before. I don't know if.
Sorry.
And also,
I don't know if you had anything else to add about.
No, I did have the issue that I raised my hand for earlier has been addressed, and so I think that's fine. I did have a question regarding the language edit. I think the original staff recommendation was, since there are no known capital expenses at this point, to budget for known expenses elsewhere in their budget and then revise to appropriate capital additions later. So I wonder if adding capital in front of expenses in that recommendation conveys that accurately still.
Yeah, it's sort of the opposite. What you're saying is budget for known non-capital expenses, essentially. So that might not have to be there, but I appreciate the clarity.
Thanks, Danielle. Zahira, you have your hand raised?
Well, I think it depends on what the, thank you. And I think it just depends on what the final recommendation is. And so if it is to the point in terms of what Danielle just shared, then I don't, but if it's something where it's capital, you know, part of this is talking about this 5,000. So like up to 5,000 in terms of the expenses. But I think it'll just depend on like what the final language is. I don't know if we could hear it in total.
Sorry, yeah, the one thing I'll say is like, right now, I think when we're talking about the staff recommendation, I think we're really working on the motion, right? Yeah, okay, just wanted to make sure.
Yeah, I think that's what was causing like a little bit of confusion, is that it's like, it's the staff recommendation that's part of bullets. So it had some of that context within it based on how it was drafted, but we do seem to be working on the motion. And so like, I'll have a better sense of whether I have a question or a comment or addition based on the actual text of the motion.
Yeah. So it seems like, yeah. Bob, you had a comment? Your hand raised?
Do we as the committee have the power to direct a grantee what to do with the money already allocated to them, as opposed to recommending that a grantee revise its budget to meet IOLTA expense, so on and so on? Do we have the power to direct any grantee?
I'll defer to Dwan and Erica, but I think the idea is like, if they don't end up with known capital expenditures, like we can't direct them to come back with those, or even if they have known capital expenditures, if they decide they don't want to allocate it to that, they don't have to. We do have some control to the extent that we approve their budgets, and if they have budget revisions over a certain amount change, we do have oversight on those. So there is some oversight that we have over how they use the money that we give them. But if they don't want to use our money in a particular way, and if they use it in a way that is still authorized, I think we don't have any other discretion. Dawn, is that an accurate statement?
Yeah, that's correct. I mean, our role is to make sure that they're using it in conformity with our rules and policy, but we don't have like a judgment call, like if one way is better than another and they're both qualifying, we can't direct them.
Yeah. Does that address your question, Bob? You're still on mute, so.
I'll go along with that. I just thought that recommends is better because, again, I don't know that we've got, as a committee, the authority. The budget revision is something we approve after they've spent the money.
You're right.
And this is not yet a spending of the money. This is a reserve, which is why I thought, you know, it's not, that's why I thought recommends is better. But if staff and our chair think directs is acceptable, I'll go along with that.
No, I think recommends makes a lot of sense. Catherine?
I guess the action we're taking. Oh, yep.
I'm sorry, Catherine. Just to Bob, to your point, I don't think we can put the directs part. We do direct them to revise their budget proposal to take out the IOLTA on that. We can recommend that they do act the capital later, but we can direct them to change their budget proposal because we're not going to approve it as is.
Okay.
Sorry, Catherine, go ahead.
I guess that's sort of to my point, is the action we can take is to say we are not approving a budget with a unspecified capital expenditure in it. That's what we can do. And then honestly, it's up to you and the staff and the program to figure it out. But what we can do is not approve a budget. That seems to be the policy that has an unknown capital expenditure in it, an unknown IOLTA capital expenditure. And in this case, equal access as well for different reasons.
Okay.
That's what I think we should be doing.
I think that's a good point. That's a fair point, is we can make the motion essentially like we will not approve it with that in, and our recommendation is that you change it this way. Would that make sense?
Sure.
You're right. We can't direct that. That's a good point. We can't really direct them.
Yes.
Okay, I see. Bob and Catherine, you both have hands raised. Do you have additional comments?
Wording changes include unknown additional capital expenses. It's convoluted to say capital additions, additional capital expenses, and then instead of and recommends that NLS, I mean, that's putting them on a parallelism. I suggest, but instead recommends that NLS revise. So unknown additional capital expenses and but instead recommends, please, instead of and instead. The but is better than and, because and is putting them on parallel, and but says, whoops, there's a difference here.
Okay.
And again, go back to
I
additional.
think capital additions is I believe is an accounting term.
Okay. Unfamiliar with that. All right. Thank you.
Any other comments or concerns with the language?
Move to approve.
Anybody up for seconding?
Erica, you guys may want to read it out loud.
Oh, good point. Thank you, Bonish. Good reminder. So the proposed motion is resolved that the Eligibility and Budget Review Committee will not recommend approval of Neighborhood Legal Services, NLS, current budget. I think we need an apostrophe showing possession there. Current budget proposal, which includes unknown capital additions expenses, but instead recommends that NLS revise its budget to remove capital additions and seek a budget revision at a later time if a capital need arises.
I have one comment. We want to say if a specific capital need arises, because that's what we're trying to get to, is the unknown of the current request.
That's fine. Sahira?
Yeah, so just in reading this language, so will not recommend approval of the current budget, but instead recommends that they revise its budget at a later time. And so in terms of the action that we're taking, because what we're taking is that we're not recommending approval, but we recommend them to revise it at a later time. When will we be doing, in terms of actually recommending their approval of their budget, in terms of what their budget says, like when will that occur? Because it seems as if we're talking about, we won't recommend the budget proposal, which means that the budget proposal won't be approved or move forward, but then at a later time, we'll have them revise it,
sure,
which will be after they've already expended the resources. And so I'm just,
I think what will happen, how it would practically play out, if I may, is that, Lynn's on this call, and even if she wasn't, what Erica and Danielle would do after the meeting at some time is to let her know that we're not recommending this. They'll go and revise it right away. We'll let you know at the next meeting it's been revised, and then you'll recommend to the commission to approve the budget. I don't anticipate it won't play out pretty seamlessly and kind of in those steps. Erica, is that an accurate summary, Erica Carroll?
Yeah, but I understand Zahira's point. The way that it's worded is, you know, at what point in time are these steps happening? You know, that they would need to make that essentially, they would need to make that change in order for it to be recommended for approval. So I don't know if you just want to take out the last part of that sentence, like that it's just known, like we're recommending that they remove it, but they also know in terms of budget revisions that they can propose that later. So if it would make it clearer just to remove the second half of that sentence.
Catherine, you're on mute.
I think the clearest thing we can do is say, we're not recommending approval of the budget, which includes unknown capital expenses, period. The rest is just what's going to happen after the fact. It doesn't need that's outside the scope of what we're recommending. Like I just don't think we're just not going to approve it, right? And the staff's going to work with the program to say, this is the action and here's the things you can do later on. But I also don't care because I think we're now like into wordsmithing, including me. So, but I just think that's the clearest approach.
Sure. I think that's a fair point. So why don't we remove kind of the recommendation and then we'll just communicate that to them.
I'll accept that as a friendly amendment.
Okay.
We still don't have a second, by the way.
Second.
Thought Louise did it before.
I did, but I'll do it again as revised.
I didn't hear you. Thank you.
I didn't say anything, Bob. I just raised my hand.
Okay. So we have a motion and a second.
I'll take a vote. Connolly?
Yes.
Mcloggy?
Yes.
Fightmaster?
Yes.
Bennett?
Yes.
Blakemore?
Yes.
Friedman? Mann?
Yes.
Meeker?
Yes.
Landfill?
Yes.
The motion passes.
Great. Okay, we have two more issues on this part. Erica, you want to move to the next one?
So one of the other issues was the deviations from the recommended expense ratios that we recommend. Organizations budget 75% or more to personnel and programs and 25% or less to non-personnel and administrative expenses. We also have a recommended ratio of 40% or less to benefits as compared with salaries. So we had two organizations that kind of deviated from those recommended percentages. One was the Los Angeles County Bar Association with their EAF proposal. 68.5% was devoted to personnel. And the reasoning that the organization provided was that they need to hire a contract attorney to coordinate their bono activities. So we're recommending approval on that. It is, it falls into a non-personnel expense for contract service to clients, but it is still, in support of providing services to clients. And so we would recommend approval on that deviation. And then mental health advocacy services had an IOLTA proposal where, benefits made up more than 40% of the salaries. And the reasoning for that was that they are hiring a postgraduate fellow from NYU, where the structure of the fellowship is such that their salary is paid by either NYU or a third party, but the benefits are not covered. So mental health advocacy services has to cover that portion, and it's skewing kind of that distribution. So they had a similar proposal last year with their EAF funds, which was approved. They had another situation with a fellowship, and this committee approved that. And so again, given that it will help them, bring on more staffing and provide more services, we're recommending approval.
Thanks, Erica. Pamela, you have a comment?
Did I read it wrong where it was indicating that the location of the individual was the cost? versus them working on site wherever the organization is working from? Did I read that wrong?
It's just with LACPA, it's just where the expenses for that person show up. They're not a full-time employee. They're not staff of LACPA. They are contracting with LACPA, but they are still providing services to clients. So it's just where it would show up in their budget proposal. But
okay, so the rent for that person's location is what they're asking for?
no, they're just asking for the expenses to pay that person. Since they are not an employee of LACPA, they fall under a contract. They're a line item called contract service to clients. And so that falls under non-personnel. So that's what's causing the deviation in the percentage, but it is the cost of actually hiring that person and having them provide those services. Not their space, it's the actual paying for their time.
Where the post office is, that's Post Street.
Did that address your question, Pamela?
I just kind of thought I read it where the person's location was different, so additional rent was required for that person. So that was my question, was where would the person working out of their actual location? Yeah, so it read like it was she was working, that there was additional rent required for her space. So
yeah, I think this is just going to like her salary. Okay. Any other questions or comments or concerns? Okay, hearing none, do you have a motion?
Move to accept the staff recommendation for both LACPA and MHAS.
Great. Do we have a second?
I'll second it.
Thanks, Bonachay. Thank you, Bob.
Connolly?
Yes.
Maflagi?
Yes.
Fightmaster?
Yes.
Bennett?
yes.
Blakemore?
Yes.
Friedman? Mann?
I'm going to recuse myself.
Meeker?
Yes.
Planthold?
Yes.
The motion passes.
Great. Thank you. All right, and then the next one.
Yes, and so the last issue in the memo was related to possible non-qualifying activities, budget proposals that include activities that are potentially non-qualifying. So the two main areas that we highlighted were proposals to fund social work positions. So social work activities currently fall outside the definition of legal services under the rules of the State Bar, but it has been a longstanding practice that the committee and the commission have approved social work as falling under the umbrella of legal services if there is a nexus to a legal outcome, and if it's a service provided in collaboration with attorneys as opposed to a service that comes after the conclusion of the legal case, or if it's just not related at all to the legal services being provided. So we had a number of proposals that intend to partially or fully fund their social work staff. We're elevating it as a group because there's nothing necessarily unique about any one of these proposals, and they have been approved in the past, but because it's not actually part of the rules yet, which is maybe a conversation that'll come up through codification, but we're elevating it to the committee as sort of a group of activities that we're recommending for approval. Bob, I think Bob has his hand raised.
Thank you.
Yeah.
Do we
Sorry.
have any guidelines about what percentage of a social worker's time has to be provided for services connected to legal outcomes, as opposed to a social worker doing therapy work unrelated to the legal issue which person is getting representation for? I mean, if a social worker did 20% on legal outcome related work and 80% of their time was on other aspects of a person or family's issues unrelated to the legal issue, is that acceptable? Do we track the amount of time or ask the grantee to give us an estimate of what percentage is directly related to the legal outcome?
Yes, so when organizations submit their applications for eligibility for the coming year, they are instructed if they have, say, social workers who engage in activities that would not be connected to legal services, that's not considered a qualified expenditure and they would need to deduct it on their application. And so similarly, with a budget proposal, they can only use IOLTA and EAF funds on what the committee and commission would consider qualifying work, meaning it needs to be tied to these legal services. So if they happen to have social work staff that is doing other work that wouldn't come under this definition, they would not be using IOLTA EAF funds for it, nor would they be counting it as a qualified expenditure in their next application round. So this would only be, in the budget proposals, they explain what activities the social workers are engaging in and the ways that they're working with attorney staff in order to have it be considered a legal service.
Helpful. Thank you.
Thanks, Bob. Banashe?
Just following up, Erica, so you mentioned that the programs that are being, that fall under this have been approved in the past. All of the programs had been approved in the past?
I believe most of them have. I saw one proposal this year from Law Foundation of Silicon Valley. I don't recall them devoting funds to social workers last year, but that being said, in their budget proposal, I clarified that they are, working in collaboration with attorneys, and they provided a pretty detailed explanation in the proposal about how this would fit under their legal services, and it's consistent with all of the other ones that have been approved before.
And how many are there in total?
There's two that have, sort of major Law Foundation of Silicon Valley Independency Advocacy Center have like entire positions funded. I'm not sure exactly how many more have, portions of social workers, like much smaller percentages. Public Law Center does, I believe a couple more do, but I'd have to go back and look at the exact number.
And how, maybe you're answering that question, how many organizations total are we looking at approving potentially here?
Yeah, that's what I mean. I don't know the exact
number
at the moment. I can pull that for the next meeting if that's something the committee.
I just want to get a sense of what percentage we're talking about in terms of our organizations who are falling under this, they're falling outside, I should say, of the current definition.
Mm-hmm. Thanks, Banashe. Pamela?
My question was for 2020 were, I know a lot of verbiage came into play in terms of the pandemic, and they were wanting us to be flexible and be considerate, and a lot of words were being tossed out in terms of service that would be provided to clients. So I'm thinking that the word social workers came up with holistic. So my comment was just how it was kind of a play on words and kind of just thrown into the mix. But again, that had to be weighed against what the state bar rules are.
Yeah, I think we've sort of, the idea was, we've sort of done this in the other, in other contexts, but the idea is like where social workers are, kind of the role that they're playing sort of helps the people with their case. We've sort of said that was part of legal services. We've done this in like the like pro bono allocation like space as well. And I think that is part of this idea that there's a philosophy about sort of a holistic approach to like legal services, that like you can't, you can't sort of give effective service to your client if you don't address their social work needs, right? That improves the case when they go into court. And that's what I think the idea behind some of the terminology. Is that addressing your question, or am I not addressing it?
Not really.
Oh, okay, I'm
The
sorry.
role of, no. The role of clerical is different from the role of the attorney. The attorney of record is responsible for the entire, how the entire transaction plays out. But like I said, a lot of words were tossed out last year to quote unquote accommodate the pandemic. So.
But I don't think this social work thing is related to the pandemic.
I know, and that's what I'm saying. A lot of things were tossed out under the umbrella of the pandemic, so they just kept tossing out a lot of things to accommodate, make it more flexible. So, but again, like I say, their role versus clerical versus admin versus attorney will need to be delineated to see who's doing what.
If I could just jump in.
Yeah, please.
So I think this approach towards social workers is fairly longstanding and, predated anything related to the pandemic, that this has been an ongoing conversation because increasingly in legal services, yes, there is a movement towards more holistic services, meaning, serving as many needs of the client as possible in one setting, as opposed to, referring them out for piecemeal services. And in particular, a lot of organizations are bringing on social work staff to that end. And so I wouldn't say that this is, in relation to the pandemic or increased flexibility so much as a continuing trend among many providers that they are bringing this in-house and working in multidisciplinary teams in order to fully serve the client and achieve, in particular, better legal outcomes. That is, one of the main goals, because they are primarily legal services providers. And so that's kind of been the rationale behind incorporating this into informally, considering it legal services. And I guess what I would also say about the proposals that do want to use this, if an organization proposed this type of work or mentioned doing this type of work in their application and it was connected to a legal service, we would not have them deducted as a non-qualified expenditure. And so it's the same rationale that we are recommending that they be allowed to use IOLTA EAF funds for it, because it's already considered, qualifying when they apply. So we wouldn't have a rationale to tell them not to do it unless, the committee and commission were to make a change to their approach or stance on this particular issue.
Okay, is this, Erica, is this something we need to actually do a motion on?
Yeah, I think because it's not codified at this point, even though it is consistent with, prior decisions, we would ask that you take a vote on it.
Okay.
Move to accept the staff recommendation of approval.
For both the social work and the previously approved activities?
Yes.
I still need to, actually the previously approved activities, I might need to provide more detail because I was mostly focused on social work there. So if you want to group those together, I can talk about that briefly.
Bob, what's your view? Do you want to withdraw your motion until?
Yeah,
Erica?
I'll withdraw so staff can elucidate on previously approved activities.
Great, thank you.
So yes, the other sort of activities that we were recommending to group together were ones that had come to the committee before as, an individually elevated activity that proposed some questions or concerns and ultimately were approved by the committee. But, the organization is proposing to use the funds again in a similar way, where it was not clear to staff whether, usually when these activities have been approved in the past, they were approved for that year in particular, but not necessarily, forever, that the committee had discretion and reserved the right to review the activities again. And so some examples are, Public Advocates is an organization that does a lot of impact work. And so 2 years ago in their impact litigation and advocacy work, they had proposed a higher education activity that was not approved. But then this year returned with that same activity during the ILA report review. And they were able to provide enough evidence to demonstrate that it was primarily for the benefit of indigent persons. And so it was approved this year. But now they're proposing to use state bar funds for that activity, their higher education activity. So that's an example. Similarly, California Indian Legal Services had, in a prior budget proposal, they were engaging in a water reconnaissance study, which was, again, meant to be broadly beneficial to indigent persons, but was not individual services from a QLSP. So that's been approved before, but they are proposing to spend funds on that again, as it's an ongoing activity. So rather than bring those individually, we grouped those together again. And so our recommendation was to approve them if staff confirms for the committee that, one, it's been previously approved, and two, the activity is substantially similar to what the committee previously approved. So.
And about how many activities are we talking about? Do you know?
Public advocates, California Indian Legal Services. Those were the two that had, had questions about them before. There's a number of other organizations that have ILA type activities, but they're routinely approved. So I would say those two organizations are the ones that had been individually kind of questioned before. The others are ILA activities, but have pretty clearly qualifying populations, such as impact litigation for individuals at risk who are homeless, or engaging in housing preservation for low-income individuals. So, yeah.
Do you have any questions on the previously approved activities prong of this?
So now I'll make the motion to accept the staff recommendation approval on both social work and previously approved activities.
We have a second. Louise will second.
Connolly?
Yes.
McCluggy?
Yes.
Fightmaster?
Yes.
Bennett?
Dane?
Blakemore?
Yes.
Friedman? Mann?
Yes.
Meeker?
Yes.
Landhold?
Yes.
Motion passes.
Okay. So the next item is recommending approval or revision of the budget proposals to the commission, but I believe, Erica, you wanted to postpone that, so I'll let you provide some information on that.
Yeah. So staff is still working with a few grantees to sort out minor administrative aspects of their application, nothing that we believe would necessarily rise to the level of the committee needing to review it, but we think that it would benefit from a little bit more time just to kind of tie up any loose ends. And so we would ask to postpone the vote until the next meeting about sort of the final list that was provided in terms of recommending approval on those. But we do anticipate that at the next meeting that should be finalized and that we would recommend approval on all of them.
Great. Do we expect that like NLS, for example, would hopefully have their budget revision in for that one? Like that would be a way to address that. Okay.
Yeah, that's one example is that we would work with NLS to update that and make sure that staff doesn't have any other kind of questions or concerns. And so just closing that out, we think we could benefit from a few more days on that.
Great. Anybody have any concerns with that plan? No, everybody's cool.
Let's
All right,
move
anything
it to
else?
sleep. Please, it's almost 1 o'clock.
Yes. Anything else that we need to address, or are we done, Erica?
Yeah, we're finished.
Okay, thank you all for your time and attention and thoughtful discussion today. This is very helpful, and we will be back together in a couple of weeks. So Thank you
Thank
very
you to
much.
all the staff again for all the amazing work.
Yes.
Lots of work here. Thank you.
Totally, totally.
And your patience. And your patience
Yes.
with us.
Great.
Absolutely.
Bye, everyone.
Thank you very much.
Bye.
Bye, everybody.
Goodbye, everybody. See you in a couple weeks.
Okay.